Hello everyone, this is Maggie Soul and welcome back to my channel, Now I Know My Rights, a channel and a platform dedicated to teaching you your rights. Today's presentation is about the top 10 things you should know about medical malpractice. Everyone relies on a doctor to heal them and to make them get better when they are sick or injured. But what happens when your physician is so unreliable that your condition gets worse? We all know that doctors owe a moral obligation, a legal duty of care, and an ethical duty towards their patients. And when they fail and breach that duty of care, the consequences could be quite serious. In fact, according to recent statistics, over 225,000 people die each year in the US because of medical malpractice. And as shocking as it may seem, only 2% of these people ever file an action for medical malpractice. The reason is people who are victims of medical malpractice often don't even know about the medical malpractice. Today's presentation is aimed to promote awareness, to make you aware and proactive to receive the highest standard of care possible, and it will show you what to do if you suspect medical malpractice. Without any further ado, let's start today's presentation.
The top 10 facts you should know about medical malpractice. All states have specific laws and regulations for medical malpractice lawsuits. The following applies to California. 1. What is a medical malpractice? Medical malpractice is defined as follows: a negligent act or omission to act by a healthcare provider in the rendering of professional services. Such act or omission must be the proximate cause of a personal injury or wrongful death, provided that such services are within the scope of services for which the provider is licensed and which are not within any restriction imposed by the licensing agency or the licensed hospital. 2. Who can be sued for medical malpractice? Medical malpractice applies to all healthcare providers and facilities licensed by the state. In California, medical malpractice laws and regulations apply to the following: doctors, nurses, anesthesiologists, psychologists, physical therapists, pharmacies, hospitals, clinics, and labs. 3. What is the statute of limitations for medical malpractice? Like any other civil lawsuit, there is a statute of limitation for medical malpractice. Adults must commence a lawsuit by the earlier of 3 years after the date of injury, or 1 year after the plaintiff discovers, or through the use of reasonable diligence, should have discovered the injury. For minors under the age of 18, the statute of limitations is the later of 3 years from the date of the alleged wrongful act, or if the minor was less than 6 years old at the time of the injury, the statute of limitation is at the minor's 8th birthday. There are exceptions to the statute of limitations in following situations which upholds the statute. These are the situations. If a healthcare provider commits fraud, if a healthcare provider intentionally conceals wrongdoing, if there is a foreign body that has no therapeutic or diagnostic purpose or effect inside the injured person's body, or in case of a minor's parent has colluded with the defendant's insurer or healthcare provider not to bring a medical malpractice action. 4. What damages can a patient sue for in a medical malpractice action? A patient can recover damages that include but are not limited to medical bills, home health care, physical and occupational therapy, lost wages, lost earning capacity, and non-economic damages such as pain and suffering. 5. Are there any caps on damages? California Civil Code 33332.2 puts a cap of $250,000 on non-economic damages in medical malpractice cases. This cap applies to damages and losses that are difficult to put a value on, such as pain, suffering, inconvenience, scarring, disfigurement, loss of the use of an organ or a limb, loss of life enjoyment. In all of these situations, there is a cap of $250,000 for damages. 6. Is it possible to get punitive damages in a medical malpractice lawsuit? In California, medical malpractice cases are such that it is possible to get punitive damages if plaintiff can show by clear and convincing evidence that the defendant committed oppression, malice, or fraud. What this means is that the defendant's conduct was despicable and done either intentionally or with willful and conscious disregard of the rights or safety of others. 7. How could you prove a medical malpractice claim? A healthcare provider is negligent if he or she fails to use the level of skill, knowledge, and care that other reasonably careful practitioners would use in the same or similar circumstances. This level of skill, knowledge, and care is referred to as the duty of care. Establishing the duty of care requires the testimony of one or more expert witnesses. In addition, a plaintiff must prove that the defendant's breach of the duty of care actually caused the plaintiff's injuries. What this means is that it is not enough that the outcome of a particular treatment or a diagnosis was wrong. There must have been something that the healthcare provider should or should not have done, which resulted in the injury to the patient. 8. What are the most common types of medical malpractice actions? Misdiagnosis. Misdiagnosis is when a doctor diagnoses you with one condition, but in reality you have another condition. For example, you are diagnosed with the flu, but in fact, you have Lyme disease. The most common misdiagnosed conditions are heart attack, cancer, stroke, Lyme disease, and thyroid conditions. Another malpractice action is delayed diagnosis. Delayed diagnosis is when a misdiagnosis happens and after some time the condition gets worse and the doctor realizes the mistake in diagnosis, such as when a misdiagnosis is about cancer and by the time the doctor realizes that he has made a mistake in diagnosis, the cancer has already spread. Another action for medical malpractice could involve surgical errors. This could be from performing a correct procedure but using non-sterile equipment, or it could be operating on the wrong body part, or operating on the wrong patient. It could also be failure to control bleeding, or leaving medical equipment inside a patient. It could be damaging nerves during the surgery, damaging tissues and organs, and it could also be improper care before or after surgery. Medical errors, from choosing the wrong medication, to wrong dosage, to ignoring allergies or medical history when prescribing a medication, are often a common action for medical malpractice. Anesthesia errors. This happens from negligent preparation to failure to inform the patient of safety procedures to actually failure to properly monitor the patient during the operation. Childbirth injuries. These are one of the most devastating medical malpractice cases anyone can endure. These could be from improper use of forceps during delivery, to surgical errors during a C-section, to oxygen deprivation to the baby, to hemorrhage of the mother. 9. What are hospital infections? It's hard to believe that ICUs, intensive care units, are among the most common places for patients to acquire hospital-associated infections. In order to qualify as a hospital infection, the infection must occur up to 48 hours after hospital admission, or up to 3 days after discharge, or up to 30 days after a surgery. In addition, it must happen in a medical facility to a patient who was admitted for reasons other than being treated for that infection. 10. Legal requirements for medical malpractice actions. Many states require the patient to first submit the claim to a medical malpractice review panel. Some states require the patient give the healthcare provider notice of the malpractice claim before filing anything. Expert testimony is required and is often a crucial feature in the plaintiff's case. Limits on damages. As we discussed, many states, including California, have a cap on non-economic damages. The bottom line is that medical malpractice lawsuits are generally very technical and complex. It may contain many deadlines that could compromise your case, if missed. If you suspect any action that could be medical malpractice, you should consult with a lawyer.